Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. We've received some questions regarding Voir Dire and if Voir Dire is open to the public, or historically, is Voir Dire closed to the public? Voir Dire is the process of jury selection, and it is currently scheduled to commence July 31st, 2025 in Idaho versus Koberger, pursuant to Judge Stephen J. Hippler's October 9th, 2024 pretrial and trial order. It is listed on page 1 of that order. Now, historically, Voir Dire in criminal proceedings is open to the public. Now, this trial order does not necessarily say that it is closed, but the question that we've received is, isn't Voir Dire typically closed to the public? And that answer is no. There are certain instances when Voir Dire will be closed to the public, but that is, to quote Judge Stephen J. Hippler in a recent order, the exception, not the norm. I'm citing to Press Enterprise Company versus Superior Court, California. This is a 1984 United States Supreme Court ruling, and the citation begins at 464 U.S. 501. That is the reporter for the United States Supreme Court's decisions. And the question that was before the Supreme Court, it had to do with a criminal proceeding. Should it be open or closed to the public? And here's what the Supreme Court held. The guarantees of open public proceedings in criminal trial cover proceedings for the voir dire examination of potential jurors. And you can find that at 464 U.S. 505 through 510 of this decision. The historical evidence reveals that the process of selection of jurors has presumptively been a public process, with exceptions only for good cause shown. The presumptive openness of the jury selection process in England carried over to proceedings in colonial America, and public jury selection was the common practice in America when the Constitution was adopted. And this is located, this discussion, at 464 U.S. between the pages of 505 and 508. Also, openness enhances both the basic fairness of the criminal trial and the appearance of fairness, so essential to public confidence in criminal justice systems. Public proceedings vindicate the concerns of the victims and the community in knowing that offenders are being brought to account for their criminal conduct by jurors fairly and openly selected. Closed proceedings, although not absolutely precluded, must be rare and only for cause shown that outweighs the value of openness. Additionally, the presumption of openness may be overcome only by an overriding interest based on findings that closure is essential to preserve higher values and is narrowly tailored to serve that interest. So, ladies and gentlemen, there you have it. That is directly from the United States Supreme Court. Again, the case is Press Enterprise Company versus Superior Court. 464 U.S. 501 is where this decision begins. It is a 1984 United States Supreme Court case. We will wait to see further if Judge Stephen Hippler makes a ruling that this case, Voir Dire, will be open or closed to the public. Stay tuned for further episodes of the Indie Zone, where we will, of course, report such a finding to you. Thank you.